Okay, Julie, I have 1 o'clock.
I'm going to call the roll and see who we've got here.
I can. Joan Corbin.
Present.
EJ Giovanetti.
I'll remind that he's no longer at that location, but he should be around there just right.
What was that again? EJ Giovanetti. Keith Luchtel.
Present.
Monica McHugh.
Present.
Rick Moraine. Rick Moraine. Julie Podorf.
Here.
Susan Stewart. Susan Stewart. Stan Thompson.
Present.
Let me go back, Julie. EJ Giovanetti, are you on the line? Rick Moraine, are you on the line?
Yes.
Susan Stewart, are you on the line? Okay, Julie, at the present time, I count 6 board members present, with EJ and Susan not present currently.
Okay. Could other people who are on the line please identify themselves?
Amy Hovers, complainant.
Okay.
Amy Glaze on behalf of the Board of Review.
I'm the complainant.
All I've gotten is Hogers. Could other people try again to identify?
This is Ralph Brown for the City of Dallas Center.
Okay.
This is Heather Wilrick, Library Board, member of City of Dallas Center.
I'm sorry, can you say that again?
Heather Wilrick with the Library Board, the City of Dallas Center.
Can you have her spell her name? Her last name?
Willllric.
Thank you.
Susan Beavers, Library Board, City of Dallas Center.
Okay.
Cindy Rieselman,
Amy Clay.
Dallas Center.
I'm sorry, Cindy who?
Rieselman,
Can we
Could
get
you
a
spell
spelling?
that, please?
yes, RIESS as in Sam, ELMAN,
Okay.
City Clerk of Dallas Center.
Well, we got a crowd from Dallas Center here. Okay.
Kelly Corey, Library Director from Dallas Center.
Is anybody at home in Dallas Center? All right.
So, this is Dusty Rauschenberg, former president of the library, resident Dallas Center.
Okay.
Can we get a spelling on that name too?
Rauschenberg, Rauschenberg.
Okay.
This is Ryan Kuhn, COON, Councilwoman in Dallas Center.
Erin Cubitt from the Iowa Hospital Association. Last name is spelled C-U-B-I-T.
Okay.
John Landy from Dickinson Law Firm.
Oh, sorry. Randy
John
Volkus
Landy.
owner of Cookie Point Tavern in Dallas Center. B as in boy, O-E-L-K, E-S as in Sam, and it's Randy with an I.
I'm going to need to back up a second. Mr. Landy, you're here for the Jason Clayworth complaint?
I am.
Okay. And now the next person.
This is Susan Eltrin on behalf of Jason Clayworth.
Okay.
Thank you.
Anyone else?
Juanita Slaughters, business owner in Dallas Center.
Juanita?
Okay.
Bob Haxton, also from Dallas Center, but on the complainant.
You're the complainant. Okay.
Yep, one of them.
Okay, do we have everybody?
This is Katie Johnston, library board meeting, or library board member from Dallas Center.
Okay.
Joanne Raymaker, last name spelled R-A-M-A-E-K-E-R, citizen of Dallas Center.
Good. You check R30 and S31. There's my town there.
I'm sorry, I didn't.
Please mute your phones.
I have no idea what that was. Somebody's phone not on.
Yeah, please mute your phones.
I'm Daniel Wilrick, a citizen of Dallas Center.
Okay. Anyone else?
Thomas Strutt, resident of Dallas Center.
President of where?
Dallas Center.
And your last name again, please.
Strutt, S-T-R-U-T-T.
Okay.
Sorry for joining late, but I am on the call now.
Okay, good. Thank you. And who was the last person who identified themselves? Susan? Okay, that was Susan Stewart. I was talking over her. Okay. Do we have everybody who's on the line?
Margaret, Amy Claves from the Board of Regents is on as well.
This is Jim Caulfield from the PerryNews.com.
Okay, and Margaret, what was your last name from the Board of Regents?
It's Amy, Margaret, Amy Claves.
I think
C-L-A-E-Y-S.
Julie, I think Amy thought I was talking instead of you.
Oh, all right.
My apologies.
Do I have everyone?
Did you get me, Julie Becker, complainant from Dallas Center?
No, I did not. Thank you. So we have both Julie Becker and Robert Haxton on as the complainants. Okay.
Correct.
Is that it?
Is EJ on?
Okay.
Julie, let's go back and check if EJ Giovanetti is on the line.
All right.
Okay, Julie, you have a quorum with 7 board members present.
Okay. Hopefully EJ will join us in a bit. Let's move to approval of the agenda. Do I have a motion to approve the agenda?
This is Monica. I'll move that we approve the agenda for today.
Second?
Keith, I'll second.
Keith.
I'm sorry, who seconded?
I think it was,
Keith. Okay, moved by Monica, seconded by Keith. All in favor of approval of the agenda, say aye.
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 Any opposed? Agenda's approved. approval of the September 17th minutes. Do we have a
This
motion?
is Rick, I'll approve. This is Rick, I'll approve.
Okay. Moved by Rick, do we have a second?
This is
Joan,
Stan,
I would
I'll
second.
second.
Okay, moved by Rick, seconded by Stan. All in favor of approval of the September 17th minutes, say aye.
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 Any opposed? Okay, the minutes are approved. Public forum. If we have anybody who wants to speak to a general topic, you may do so now. If you're here on a specific case, I'd ask that you wait until your case is called. Okay.
Julie, this is Monica. Do we want Margaret to announce the rules for the electronic meeting?
You know, we really should. Thanks for reminding me, because some people are certainly on the line who haven't been through these electronic meetings. Do you want to go through the rules for conduct on the call, Margaret?
Yes, I can do that. First off, I would note that we'll include in our minutes that this is an electronic meeting pursuant to Iowa Code Section 21.8, because an in-person meeting is impossible or impractical due to concerns about COVID-19 and social distancing for the safety of board members and the public. And we do have electronic meeting guideline outline. This is included on the agenda. It's on the last page. The rules are as follows. 1, each agenda item will be called in order. 2, IPIB staff will introduce the agenda item. 3, other parties to the agenda item will be asked for comment. First the complainant, then the respondent. 4, chair will ask IPIB members for comment, and members will be called on alphabetically. 5, chair will request a motion and second. 6, there will be a roll call vote on each agenda item in sections 5 and 6 if necessary. On 6. 7, we request that speakers other than IPIB members identify themselves before speaking. Only speak when the chair acknowledges you. 8, place phones on mute, not on hold. And 9, speak directly into your phone. Please, no speaker phones.
Thank you, Margaret. Comments from the chair. You know, as frustrating as we've sometimes found electronic meetings, the one thing I have appreciated about them is that everyone can participate, and we haven't had some members on Zoom, for example, and the public not able to fully participate in the meeting. I'm inclined to stick with the electronic as long as we're required to do so under COVID-19 problems. But if board members have a concern that we need to try to have an in-person meeting through Zoom or some other mechanism and make arrangements for the public to have it by stream, please send me an email with your comments. Otherwise, until the building's open and we can resume meeting in person, I think we'll try to stick with conference calls. Let's move on to the agenda for board cases involving deliberation or action, starting with the Joshua Baker matter.
Yes, this is...
Margaret, can you summarize that?
Yes, Joshua Baker is case number 19 FC 0108 involving the city of Sheffield. You have before you a revised final report. If you recall, there was a request at the last meeting from Mr. Baker to see if we could get a copy of one specific record.
I'm getting a lot of background noise. Somebody's not on mute. Please adjust your phone so we don't get this background noise. Okay, go ahead, Margaret.
Right. If you recall, this was continued over to see if there was one additional record that the city had been unable to locate, and if that could be located and provided to Mr. Baker. And in that last month, the city was able to provide a copy of the language of the previous city policy by releasing a copy of the resolution that changed part of the language when the policy was amended. So this document that was part of one of the minutes, I think, contained the prior language as well as the modified language. So they had not retained a copy of the actual document, but by utilizing the resolution to amend the policy, they were able to provide both the old and the new language. So at this point in time, the recommendation is that the IPIB agree to dismiss the complaint as resolved, and we prepared an order to that effect. I'm not certain whether Mr. Baker decided he wanted to speak or not.
Mr. Baker, are you on the line, and do you care to speak? I appreciate staff's effort to find that last document. Would work on that. Why don't we get comments from board members? Brett?
Corbin?
No comment.
EJ, have you joined? Keith?
No comment.
Monica?
No comment.
Rick?
No comment.
Julie?
Nothing other than to reiterate my appreciation for everybody's effort to get that last document tracked down.
Susan?
No comment.
And Stan?
No comment.
Okay, do we have a motion to approve the revised final report and dismiss the complaint?
Keith, I'll move it.
This is Monica. I'll second.
Moved by Keith, seconded by Monica. Roll call vote.
Corbin?
Aye.
Giovanetti, are you on? Luchtel?
Aye.
McHugh?
Aye.
Moraine?
Aye.
Podorf?
Aye.
Stewart?
Aye.
Thompson?
Aye.
Julie, that's 7 votes in favor, 0 against.
Okay. The resolution is accepted and the complaint is dismissed as resolved. Number 2, Troy Beatty. Could you summarize that for us, Margaret?
Yes, this is case number 20FC0087 involving Troy Beatty and the Evansdale Waterworks as the respondent. On August 27th, he filed this complaint alleging a violation of Iowa Code Chapter 22 by the Evansdale Waterworks. He alleged that Mr. Beatty is the mayor of Evansdale, and he had requested from the Waterworks 5 copies of 5 years of. I'm sorry.
What is the background problem again?
Please put your phone on mute.
Okay.
Thank you.
Mr. Beatty is the mayor of Evansdale, and at the council's request, he requested copies of 5 years of timesheets and the operating handbook from the EWW on August 5th, and he alleged that his request was denied on August 19th. And when legal counsel contacted IPB on September 4th, indicated that he would file a response to the complaint. On September 14th, legal counsel again contacted the IPIB and indicated that he was trying to retrieve the required records. On September 30th, Mayor Beatty advised us that he received some records, but was still missing the 2020 documents. No information was provided by the EWW or its attorney to explain this delay. And at this point in time, we believe it's appropriate to accept this, to resolve not only this complaint, but to maybe assist the EWW in coming up with a records policy and trying to determine why their records request couldn't be easily and quickly resolved. So the request is to accept it.
Okay. Waterworks. Nope. Let's move on to board comment. Brett?
Joan?
No comment.
EJ, have you joined us? Keith?
No comment.
Monica?
No comment.
Rick?
No comment.
Julie?
Nothing.
Susan?
I do have a comment. When I read this complaint, I thought, why are we not dismissing it because it's one department complaining against another department? I did a little bit of research and I found out that the waterworks is governed by the Evansdale Waterworks Board of Trustees, which is a separate governmental body. Some cities are organized that way, so my recommendation would be in that second paragraph where it says EWW, that it's a Evansdale Waterworks Board of Trustees, so it's clear we have two separate government bodies disputing with one another here instead of two departments of the same body.
Okay. Then we have a motion to approve the acceptance order with Susan's amendment.
Hold on, Julie. Stan, did you have any comments?
I did not. No comment.
My apologies, Stan. I didn't mean to.
Oh, that's fine.
Now, do we have a motion to accept the order with the suggested amendment by Susan?
I would move that.
Okay.
This is Stan. I'll second.
Okay, moved by Susan, I think seconded by Stan. A roll call vote.
Corbin?
Aye.
Giovanetti? Luchtel?
Aye.
McHugh?
Aye.
Marine?
Aye.
Podorf?
Aye.
Stewart?
Aye.
Thompson?
Aye.
Julie, that's 7 in favor and 0 against.
Okay, the acceptance order is approved as amended. The next item on the agenda, Becker and Haxton, the Dallas Center Library Board. Margaret, can you summarize for us?
Yes, this is case number 20FC0077. This is a sort of a two-part complaint. Initially, the complaint was filed just by Julie Becker on July 25th, 2020. And then on August 7th, just before the last meeting, she requested to amend her complaint. And she was joined in that amended complaint by Robert Haxton. The initial complaint alleged that on May 26th, she requested materials for a May 27th, 2024 meeting, and that the Dallas Center City Clerk did not provide her the materials 24 hours in advance of a public city library board meeting. And then she indicated, and it's quoted on the first page there, that the city clerk had informed her on more than one occasion that the city clerk does not have to provide the public with materials to be discussed at the library board. And her original complaint then further alleged that she felt that without putting that there was a problem with the agenda, that it didn't adequately indicate what was going to be discussed at the meeting. She included in her complaint a recitation of events surrounding the board decision to approve the contract amendment. And she also provided a copy of the agenda for the board meeting in question, and that's included as attachment A. She requested that the IPIB require the city to post more descriptive, or in this case it would be the library board, to post more descriptive agendas, and that the IPIB void the library contract. The city attorney responded. He noted that the agenda was sufficient and posted 27 hours prior to the meeting. He stated that Chapter 21 does not require posting of board materials, and that the clerk had treated the request for board materials to be a request for public records, which she was able to provide within 5 hours and prior to the board meeting. Then the amended complaint added a new subsection of the complaint indicating that the May 27, 2020 meeting minutes were inaccurate, and the minutes are specifically state, and are listed there on the second page. Mr. Brown responded to the additional complaint and stated that the board meetings meet the requirements of Iowa Code Section 21, which requires that meetings show the date, time and place, the members present, and action taken at each meeting. The minutes shall show the results of each vote taken and information sufficient to indicate the vote of each member present. There was an audio recording, and upon review of that, it appeared that the motion may have been a little inartful and perhaps kind of confusing, but it did meet the requirements in that they accurately show the results of the vote taken by roll call and indicate the vote of each member present. My recommendation is to dismiss the complaint as legally insufficient because the notice, agenda, and minutes were legally sufficient, and there was no evidence of any violation of Chapter 21 or 22 by the board.
I know both of the complainants, Julie Becker and Robert Haxton, were on the line. Shall we start with Julie Becker? 5 minutes if you'd like to address the board.
Yes, I would like to address the board, and I'd like to ask them not to dismiss this. I don't think that the explanation given adequately describes my complaint. 2 years ago, I was here at the board arguing that $1 copies were unreasonable, and I didn't technically win, but after arguing at the board here, I now am able to get copies for 10 cents and a lot of times free digitally because it was unreasonable. Now I'm up against the same clerk, the same lawyer, and the same group of people from Dallas Center here asking for one thing, that when I attend meetings in my city government, that I be provided the materials of the meeting 24 hours in advance. That is the heart of my complaint. It is that I am constantly being refused to be provided materials for meetings that I attend 24 hours in advance. And I don't think that's unreasonable, but yet the city felt it was so unreasonable that they've engaged the lawyer for an additional $250 an hour above his retainer to fight this with you all. And as you've seen, they've all shown up to fight it as well. I think this question of whether people, the public, are entitled to information 24 hours in advance is very important and needs to be addressed, and that is what my complaint addresses. And it addresses it by, in a nutshell, the fact that at this particular meeting in May, neither the cryptic agenda or inaccurate minutes indicate that an action to approve a $118,000, $646 contract amendment would occur or did occur. The only way the public would have been aware of the approving of this $118,646 contract amendment would have been by being provided the meeting materials, which in spite of numerous requests were not provided until 7 hours in advance of the meeting, and only because I constantly requested the information. I have had this problem before with the city clerk. When I request information materials of the city clerk 24 hours in advance for a meeting I'm going to attend, for an agenda that has been posted 24 hours in advance, I have been repeatedly told by the city clerk, and I quote, "There is no requirement in Iowa law that you be provided prior to the meeting with copies of any materials that will be distributed to the library at their meeting." This has been told me several times, and I am left at the mercy of the city clerk as to when I can get materials that will be provided at the city meeting. This doesn't seem fair to me as a person in the public, and it certainly doesn't seem to promote transparency. If expecting to be provided materials 24 hours in advance is unreasonable, then I'm wanting the board to explain to me when, as a person in the public, appreciate your time.
Your comments, Becker. Is Mr. Haxton on the line? Mr. Haxton?
Hello? Do you hear me?
Yes, I can hear you. Would you like to
Okay.
address the well?
You bet. Robert Haxton. And then,
Have 5 minutes.
okay. I want to mention on the initial complaint on July 27th, to clarify the records, I was listed as a complainant. Okay. So that was the original complaint file. Before we get into details, I want to call your attention to the following statement in the Iowa Open Records Handbook, which states in Chapter 21.1, quote, this chapter seeks to assure through a requirement of open meetings of governmental bodies that the basis and rationale of government decisions, as well as those decisions themselves, are easily accessible to the people, end of quote. So as you consider this case, I would want to remind everyone this is why Julie Becker and I are here, to ensure that in the city of Dallas Center, records are easily accessible to the public. Okay, the first point, meeting materials not provided at least 24 hours in advance of the meeting. The city clerk failed to provide all meeting materials 24 hours in advance of the library meeting on May 27th. Failure to provide all meeting materials has been a repeated occurrence for several months. Contracts and financial documents can be complex, and the need at least 24 hours for the public and the board who render decisions to adequately review them. The Attorney General's opinion in 1981 in Stark to McDonald stated that material prepared for discussion at public meetings are public records and should be made available to the public when they are made available to those sitting on government bodies. According to 21 of the Iowa Code, 24 hours seems to be the standard for meeting openness, for posting meeting agendas, and it would follow for providing meeting materials. Second, failure to provide informative agenda, noting actions to be taken. The library agenda for May 27th did not state that the library board would approve an amendment to the contract with Estes Construction for $118,646. For a small city like Dallas Center, this is a significant amount. The agenda merely states, quote, new 2020.7 updated Estes contract, phase 2, end of quote. Nowhere does the agenda state that a contract for $118,000 was to be approved. Third point was on the library minutes. Do not accurately state what has transpired at the library meeting. An audio recording of the meeting indicates a motion was made and the library board approved this contract for $118,000. However, the library minutes do not state that a contract was approved. The minutes merely state that it was approved to begin phase 10 of the addition remodel project. Nowhere is it mentioned in the agenda or the minutes that a contract amendment for $118,646 would be approved or was approved. Approval of the contract only exists on the audio recording of the meeting. The minutes of the meeting failed to state that this contract for $118,000 was approved. Merely phase 2 was to begin. Therefore, the minutes, in addition to the agenda, are erroneous and misleading. And I would just further comment that when we go to look and find out what happened in the city in prior months and years, The minutes accuracy is a key thing. In conclusion, for the sake of open government everywhere, I strongly recommend that you hear this case. Thank you, Bob Axton.
Thank you, Mr. Haxton. We have a large number of people from Dallas Center who are on the line. Mr. Brown, are you here to speak for the respondents?
I am, Madam Chair. Thank you. The people from Dallas Center, I think, are here simply to listen to the board deliberations. I am the attorney for the Dallas Center.
I'm sorry, Mr. Brown, just a moment. Brett?
Yeah?
This is EJ. I just want you to know I'm on the line.
Okay, EJ.
Oh, I thought Brett had a question. Welcome,
Thank you.
EJ. Okay, please
Thank you.
continue, Mr. Brown.
Thank you. I'm the attorney for the Dallas Center City Clerk and the Library Board of Trustees. Director Johnson, I believe, has accurately analyzed the 3 open meeting violation allegations. She's correctly recommended dismissal. I believe what you heard today from the complainants has added nothing to change the recommendations. The first charge is as a city clerk violated the open meetings law by not providing a copy of the library board's meeting materials 24 hours in advance. There is no requirement in Iowa law that these materials, unlike an agenda, must be available 24 hours before a meeting. The library director, who is on the call, prepares the packet of materials for the board on the day of the meeting. And once those materials are prepared, she forwards them to the city clerk. The materials are not available 24 hours before the meeting. These meeting materials are public records, and the city clerk promptly complies with the complainant's public records request by electronically providing to the complainant these materials once they've been prepared without charge. And it's important, as Ms. Johnston notes in her proposed order, the city clerk is not a governmental body, therefore is not subject to the open meetings law. Second charge is that the library board did not post what the complainants refer to as an informative agenda for its May 27th meeting. Board's agenda was posted more than 24 hours before the meeting as required. The agenda items included updated Estes contract phase 2. The agenda is legally sufficient as it reasonably apprises the public of the matter to be considered. It gave notice the library board would consider a recommendation the city council approve an updated contract, Estes Construction, for construction management services for phase 2 of a library project. This only covers management services. It's not a construction contract. That's important. The library board was making recommendations. It was not signing off on contracts. Those contracts went to the city council. The city council had to approve the contracts. Following, on May 27th, the library board's recommendation, at its next city council meeting, the city council approved that updated contract. The third charge is library board's minutes of its May 27th meeting are inaccurate. As Ms. Johnson states, the minutes meet all of the requirements of Section 21.3 of the Code by reporting the results of a roll call vote on an action item. For more than 2 years, our community's plans for library remodeling and addition construction have been well known and discussed in Dallas Center. These plans have been opposed by the 2 complainants as they attend every library board and every council meeting, and they express their opposition to the project. Since the May meeting, the council has awarded contracts, and the library addition construction is now underway. There is no basis law to the complaint. We support Ms. Johnson's recommendation. The complaint should be dismissed. Thank you.
Okay, there are a large number of other people from Dallas Center, but I've assumed that Mr. Brown speaks for the interests of the respondents.
That would be correct, Madam Chair.
Okay. Let's go on to board questions and comments.
Joan.
Brett?
No comment.
EJ, any comments? Questions?
No comment. No comment at this time.
Keith?
No comment.
Monica?
No comment.
Rick?
No comment.
Julie?
I have a question for Mr. Brown. From the way you've described events, are you saying that the board members themselves don't see the agenda materials until 7 hours in advance of the meeting?
I believe the library director prepares those materials on the day and sends them to the board members that day electronically.
And then they're
I
available
believe
for the
we
public?
stated that, when they're available for the public, yes. And we reported that information in the response that we filed with the board.
Is it possible to prepare the materials, and I'm surprised the members don't ask for this, earlier than the day of the meeting?
The library director is on the call if you'd like to ask her procedure.
And I don't remember
Shelley
which
Corey.
person.
Shelley Corey is the library director.
Our past procedures have been to provide the library board members with the meeting materials actually at the time of the meeting. However, within probably the past year, I have made the materials available to the board members by email the morning of our meeting so that they have that day to look through them. I am still processing invoices up to the day of our meeting. So that's been my practice, to have the materials ready the morning of the meeting to send out to my library board members. And then I also copy in the city clerk.
That is a fairly short amount of time to look through the materials the day of the meeting. Is it possible that they could be prepared earlier?
We have discussed it at a library board meeting, and all of my library board members did not have any issues with needing to receive them sooner. My library board packet usually consists of about 4 to 5 pages.
Really?
And it's pretty standard every month. It's our minutes, our bills, upcoming events, and then anything in addition. So that usually ends up being just about 4 pages.
Okay. Thank you.
Mm-hmm.
Susan?
No comment.
Stan?
No comment.
That's everyone. Julie?
Okay. Do we have a motion on the dismissal order?
This is Rick. I'll move to dismiss.
Do we have a second?
Keith, I'll second.
Okay, moved by Rick, seconded by Keith. Roll call vote.
Corbin?
Aye.
Giovanetti?
Aye.
Lochdahl?
Aye.
McHugh?
Aye.
Moraine?
Aye.
Podorf?
You know, I'm going to vote aye because the materials are so brief. Aye.
Susan? Stewart?
Aye. Aye.
Thompson?
Aye.
Julie, that's 8-0 in favor.
Okay, the dismissal order is approved. I want to thank everybody for their time in attending the meeting electronically, and the complainants and Mr. Brown for their comments, as well as the library director.
You're welcome.
Next item on yeah. The next item on our agenda is Heather Carlson,
Yes.
Davenport Community School District. Margaret?
Yes, this is case number 20. I'll wait till it stops speaking.
Yes, we have massive numbers of people hanging up here.
You should have made everybody listen to the rest of our meeting.
Okay, this is case number 20, FC0080. It is Heather Carlson as a complainant, and the Davenport Community School District Board of Directors as a respondent, and it's before the board as a dismissal order. This was filed on August 21st, 2020, with an allegation of a violation of Iowa Code Chapter 21 at a meeting on June 22nd. It's kind of a technical violation in that they had a closed session, and there's no dispute that the closed session was inappropriate. The allegation is that the board should have used 21.51I rather than 21.51A as the reason for that closed session. And the complainant asked that the IPIB require the board to provide information concerning the discussion that took place in that closed session. The agenda said that the reason for the closed session was to review or discuss records which are required or authorized by state or federal law to be kept confidential. This is the rationale in 21.5 sub 1 sub A. Ms. Carlson alleged that the true purpose of the closed session was to discuss her client, Dan Burlingame, who was being considered for a different position with the school district. She alleged that he should have been given the opportunity to agree or not agree to the closed session. In response, legal counsel indicated that there was an earlier meeting in May 26, 2020, during which this plan to hire Mr. Burlingame was removed from the agenda due to an allegation made against him by another employee. After that, there was a investigation that was conducted by a school administrative person to investigate this allegation. That investigation entailed talking to various employees of the school district, including the complainant and the individual that was being complained about. Because of that, the school district legal counsel determined that it was a record that they were discussing. They were discussing the actual report that needed to be kept as confidential because it involved the information involving more than one employee. So it wasn't a 21.51I closed session, which would be specifically to evaluate the professional competency of an individual. So in order to maintain the confidentiality necessary in this report, it was important to have that be the reason for going into the closed session. So as noted here, conducting a closed session to discuss a confidential record is an appropriate way to protect the confidentiality of that record. Therefore, in this situation, the use of 21.5 sub 1 sub A would have been appropriate and not a violation of Chapter 21.
Okay, do we have anybody here representing the parties, either Heather Carlson or someone from the Davenport Community School District? Nope. Then let's move on to board comments.
Joan?
Recognizing that your recommendation, Margaret, is to dismiss, I'm not quarreling with that, but wondering if you had any conversation that leads you to believe that the board is aware of the differences between the sections that were used to warrant a closed session?
Yes, Wendy Myers, the legal counsel for the Davenport Community School District Board of Directors, and we've actually had her involvement in the past on other legal issues. So I think they're very fully aware, and at least in the response she provided to me, I thought it was she provided all the information probably that Ms. Carlson needed, by telling her probably more than she absolutely had to on that, but outside of giving her the conversation, she indicated that here's the rationale that they used, because they considered both. But if you use I, then, and you're talking about more than one person, the question becomes, how do you honor the ability of one of those people to have a closed session if another person who's in dispute with that person says, no, you're not, we're going to have an open session. So I think that's the only way to really protect the confidentiality of the record, which is that actual investigative report.
Very good. Thank you, Margaret. No further questions?
EJ.
No question.
Keith. Monica. Rick.
Yeah, I want to make sure I understand. Was Mr. Becker's professional competency being evaluated during the closed session, regardless of whether it was by a written record or orally?
It was actually, it was a discussion of the results of the investigation, which turns out that the school board determined that the complaint against Mr. Burlingame was not founded, and that's come out through various other legal action that's going on. There's legal action going on involving his
I'm sorry, I said Becker instead of Burlingame. That's my error, and I apologize. I just want to be clear. If suppose the discussion were given orally rather than from something that was written down, would that have made a difference?
That very likely could have. In this case, it was an actual investigative report that was prepared by administrative official with the school district that was that was presented to the board. And we've had this before, where if you are discussing something in an open session, then that document becomes a public record. And so I think that was part of the reason why they wanted to make sure they had a closed session, to protect that confidentiality.
Was Mr. Burlingame consulted as to whether he wanted that record to be discussed in closed or open session? I don't want to belabor it, but I'm a little concerned about what his rights were in this.
I don't think he was asked if he had. It's complicated in that this is the third complaint, and so you'll see that one of them was withdrawn, and last month another one was dismissed. All of them had to do with his employment by the school district. And subsequent to the filing of all of these complaints, there was a news article just recently that the state Board of Education is actually taking over the running of this school district. So, I'm not sure how to. I don't think he was given the chance to review the report and determine whether or not he wanted it to be an open or closed session. I don't think the witnesses that were questioned and were part of that report were given that possibility either.
Yeah, thank you. That helps. I just don't want us to end up leaving a wide open gap for public bodies to say, well, this is a written report, so we're going to go closed with it, without giving the employee the chance to decide whether or not it's to be open or closed. Thank you.
Mm-hmm.
Julie?
Nothing from me.
Susan?
Nothing from me.
Stan?
No comment.
That's everyone, Julie.
Okay. Do we have a motion on the dismissal order?
This is Monica. I'll move that we accept the dismissal order.
This is EJ. I'll second.
Okay, moved by Monica, seconded by EJ. Roll call vote.
Corbin,
Aye.
Giovanetti,
Aye.
Luchtel,
Aye.
McHugh,
Aye.
Moraine,
Aye.
Potterf,
Aye.
Stewart,
Aye.
Thompson.
Aye.
Julie, that's 8 votes in favor and 0 against.
Okay, the dismissal order is approved. The next item on the agenda is the Jason Clayworth complaint against the Des Moines Water Works. We have a report.
That's correct. And this is case number 19 FC 0138. The board may recall that this complaint was filed in November of 2019, and it was accepted by the IPIB on July 16th, and then it was given back to staff to work on some sort of a informal resolution to see if one was possible. This was worked by Zach. Actually was doing this. He's home sick today with like laryngitis and had a fever, but so he's available. He's listening in on the phone, but he's not available to speak. So I'm going to just kind of do a brief presentation. It's my understanding that counsel for both Mr. Clayworth and for the Des Moines Water Works, who actually, the two of them together, put together this proposed joint stipulation and proposed form of decree that you have, and they're available to answer questions if you have any questions. But basically, they have figured out a way to release the document in question to Mr. Clayworth with some protected provisions, or actually, I guess, indicating that they're not agreeing that they had a legal duty to release the document, but that they informally, as part of informal resolution, are willing to do so. So if there are additional questions, I certainly think both attorneys are available and can speak briefly as to what is before you.
Do we have any comments from the attorneys?
Sure. This is Susan Elgin on behalf of Mr. Clayworth. I don't have much additional to add. Just wanted to say, thank you for the opportunity to address the board again. And the report that you have before you, following the board's July meeting where the board accepted Mr. Clayworth's complaint, Mr. Landy and I have worked together on this to conciliate this matter. We've done so through providing the board with this stipulation of facts as well as a proposed decree for the board to enter. This will allow for Des Moines Water Works to produce the settlement agreement at issue to Mr. Clayworth, and it will fully resolve this matter. So I just ask that the board agree to the terms that the parties have agreed upon, and I'm available for any questions that you might have.
Any comments from you, Mr. Landy?
Yeah. So I just want to kind of reiterate, because we've had some periods where we haven't had this complaint in front of the board, kind of what Des Moines Water Works' position here is. Des Moines Water Works really had two concerns in this complaint. The first is it didn't want to release a document that wasn't a public record because it didn't want to disclose information that shouldn't be made public if it wasn't supposed to be made public. And secondly, Des Moines Water Works has a concern about being obligated to produce records of its independent contractors going forward. And so that's the reason for Des Moines Water Works taking the position that it did here in this case. I want to, first of all, agree with kind of staff summary and Ms. Elgin's summary here too about what the report is that's been given to the board. Des Moines Water Works recognizes that the board has spent a substantial amount of time already processing this complaint before it even got to the acceptance stage. And so in recognition of that fact, we understand that the board members may have had their opinions crystallized more at this point than they ordinarily would in the stage right after acceptance of the complaint. So recognizing that, what we've agreed to is to, in essence, submit this to the board for final resolution on a set of stipulated facts. And if the board makes the decision that the settlement document that's in question here, is a public record under Chapter 22, the Des Moines Water Works will release it. Des Moines Water Works is not, as you see from the proposed form of decree, necessarily agreeing with the legal position that the board would adopt by releasing the document. But as I said, we recognize that the board's already devoted substantial time and attention to this, and therefore, if that's what the board is inclined to do, then we're agreeable to providing the board with a vehicle for just bringing this matter to a resolution.
I appreciate the efforts of both attorneys getting this resolved. Comments from board members?
Joan?
No comment.
EJ?
No
Keith?
comment.
None.
Monica?
No comment.
Rick?
No comment.
Julie?
Nothing further.
Susan?
I would just thank the parties for this resolution. I think it's a good resolution from my perspective.
Stan?
I would join the comments that compliment council for getting this resolved.
That's all, Julie.
Do we have a motion? Okay, thank you, Brett. Do we have a motion to accept the informal resolution report?
This is Susan Stewart. I was so moved.
This is Joan. I would second.
Okay, moved by Susan, seconded by Joan. Roll call vote.
Corbin?
Aye.
Giovanetti?
Abstain.
Lochdahl?
Aye.
McHugh?
Aye.
Moraine?
Aye.
Podorf?
Aye.
Stewart?
Aye.
Thompson?
Aye.
Julie, that's 7-0 with one abstention.
Okay, the informal resolution report and the joint stipulation is approved. Thanks to the parties. Next item on our agenda, Michael Dominic and the Benton County Sheriff's Department. Margaret, can you summarize, please?
Yes, this is case number 20 FC 0085, Michael Dominic and the Benton County Sheriff. It's before the board as an acceptance order. The complaint was filed on August 26th. The complaint alleged that there was a flat fee charge of $25 for a copy of the video on a flash drive that Mr. Dominic had requested. He alleged that the cost was in excess of the actual cost of fulfilling the record request as required by Iowa Code Chapter 22.372. And you see as an attachment the actual policy that the Benton County Sheriff's Office has been using. And note that they indicated this is a discovery request, not necessarily a public records fee policy. The chief deputy indicated that this fee policy, it has said $25 for some period of time, and that he was not able to provide a breakdown of cost to discover what the actual costs were. I'm recommending that we accept this complaint because it's confusing discovery and public record requests, and they're two separate things, and I think they need to prepare a policy that's actually for public records and is based on actual costs and not utilize their discovery policy or their discovery sheet that they hand out and use in criminal discovery. So that's the reason for the acceptance.
Is either Mr. Dominic or anybody from the Benton County Sheriff's Office on the line? Let's go to board comment.
Joan?
I think that the acceptance is warranted.
EJ?
No comment.
Keith?
No comment.
Monica?
No comment.
Rick?
No comment.
Julie?
I agree with the acceptance order.
Susan?
No comment.
Stan?
No comment.
Okay. Do we have a board motion to accept the acceptance order?
This is EJ.
This is Stan. I'll move.
I'll second them.
Okay, moved by Stan, seconded by EJ to accept the acceptance order. Roll call vote.
Corbin?
Aye.
Giovanetti?
Aye.
Lochtel?
Aye.
McHugh?
Aye.
Moraine?
Aye.
Hodorf?
Aye.
Stewart?
Aye.
Thompson?
Aye.
Julie, that's 8-0 in favor.
Okay, the acceptance order is approved. The next item on our agenda, Amy Hohertz versus the Iowa Board of Regents. Margaret?
This case is case number 20 FC0090 involving Amy Hohertz as complainant and the Iowa Board of Regents. The complaint was filed on September 2nd of this year, alleging a violation of Iowa Code Chapter 21. She described the violation, and the actual language is listed from her complaint, that there was a letter that was published by the University of Iowa and the Hawkeye Athletics community on August 21st, 2020, signed by the athletic director and the university president, that stated, in consultation with the Board of Regents, State of Iowa, we have made the decision. And the decision was alluded to have been made since sometime in August, like August 11th. Excuse me. I need a drink of water. Her allegation is that there hadn't been an open public meeting during that period of time that this decision was supposedly made, and so therefore there must have been a closed, unnoticed meeting that occurred in which the Board of Regents made this decision. Legal counsel for the board responded that, number one, that the complaint did not meet the requirements of our administrative rule, which is listed there, and two, that at no time did a majority of the board meet outside of a properly held open meeting. In support, of course, counsel provided our rule, which I have put in full at the bottom of page 1. And then went further by providing sworn affidavits from the executive director of the board, the president of the board, and every board member. Those affidavits were certified under penalty of perjury, and each affidavit said there was no gathering of a majority of members of the board for the purposes of deliberating or taking action upon the decision to eliminate certain sports at the University of Iowa. Then 6 of the affidavits added that on or about August 14th of 2020, each had received an individual call from the president of the University of Iowa informing each one separately of his decision to eliminate 4 varsity sports. Another board member included in her affidavit that she participated with 2 other board members, Richards and Bettinger in a virtual call on August 3rd with the University of Iowa staff, who informed the three of them that the staff was considering the possibility of eliminating some varsity sports. She also reported that individual on an individual telephone call from the president. Two other board members, Richard and Bettinger, in addition to all the previously mentioned certificates, stated that the two of them had participated in a conference call on July 31st, at which time they were informed that staff was considering the possibility of eliminating sports. Mr. Brund, who's the executive director of the board, stated in his affidavit that it is, quote, the policy of the Board of Regents that control of athletics at each Regent University is delegated to the president of the university. Specifically, the decision to eliminate a varsity sport is delegated to the president of the university. And that policy is also restated in a footnote. On October 14th, after this order was drafted, his affidavit was amended to add the following language. At no point in time was I acting as an agent or proxy for any member of the Board of Regents. He certified that he was called by the president of the University of Iowa and informed that the president had decided to cut 4 varsity sports. He then asked the president to contact each board member individually and relay that information prior to the release of his decision to the general public. Upon receipt of the board's response to her complaint, she submitted additional comments. In the comments, she was unable to provide any more details because there's no way for her, of course, to know whether a meeting was held if there wasn't notice or agenda or minutes. And that she she argued that the actions of the board's executive director and the 3 board members who participated in that conference call should be considered a violation of Iowa Code. And in doing that, she referenced Iowa Code sections 262.9.4 and 262.9.10 as requiring the board to take responsibility for these decisions. This is not an allegation of a violation of Iowa Code Chapter 21. There was a video clip that was provided from the September 23rd, 2020 public meeting of the board, during which time the athletic budgets of all 3 universities were presented and discussed in open session. That the portion of the meeting addressing the athletics budget can be accessed at a link, and I was able to do that. Iowa Code defines a meeting as a gathering in person or by electronic means of a majority of the members. In this case, there's no information. In fact, there's sworn affidavits indicating that at no time did the majority of those members meet. Therefore, there was not a meeting as defined by code during that period of time, and the complaint is therefore legally insufficient, and that would be the grounds for dismissal.
Ms. Hohurt's on the phone.
Yes, I'm here.
Okay. Would you like to address the board?
Yes, I would. Thank you.
You have 5 minutes.
Okay, thank you. On July 29th, 2020, and I would ask you to reference the document that I sent to Mrs. Johnson before the meeting. On July 29th, 2020, the Board of Regents announced university athletic budgets would be discussed in their September meeting due to, quote, the uncertainty of fall schedules. You'll see an image from their website on that document, the last sentence. From their affidavits, we know that Regent President Richards, Regent Bunker, and the Executive Director met with U of I Athletic Director via conference call merely 2 days later on July 31st, and that Regent Bates joined these same persons in a virtual call on August 3rd. During both of these meetings, quote, university staff informed them of potential cuts to athletic programs. The executive director, who is not a voting member of the Board of Regents, further stated in his affidavit that on August 14th, quote, President Bruce Harold phoned me individually to inform me that he had made the decision to eliminate 4 varsity sports, end quote. The executive director then advised President Harrell to contact each member of the Board of Regents to announce that decision. I contest that these actions violate Chapter 21. The Board of Regents, per Iowa Code 262.9.4 and 262.9.10, are to, quote, manage and control the property, both real and personal, belonging to the institution, and direct the expenditure of all appropriations made to said institution and of any other monies belonging thereto. Thus, by law, the Board of Regents is responsible for managing, controlling, and directing the University of Iowa Athletic Department budget. The U of I leadership wants the residents and taxpayers of Iowa to think that open oversight and approval of the athletic department occurs. In their open letter on August 21st, they made specific point to say that the decision was, quote, in consultation with the Board of Regents, end quote. This contrasts with what the Regents' own affidavit said, where there was no consultation made, but rather just notification. The Board of Regents also wants the residents and taxpayers of Iowa to think that they are providing open oversight and approval of the athletic department. In every budget approval meeting of the Board of Regents, the athletic department budgets are included in the overall budget to be voted on. This includes their most recent meeting of September 23rd. They quote-unquote voted on the athletic department budget. However, the Regents had in effect already approved the University of Iowa Athletic Department budget as of August 14th. The program cuts had been announced and put into motion on August 21st, and the budget that was presented to the Board of Regents by the athletic department or the athletic director himself on September 23rd had not even been updated after the Big Ten announced the details of a modified fall football schedule more than a week prior to that meeting. This public vote that was taken on September 23rd was nothing more than a sham. They want people to think that there's oversight, and there is none. In this time of the pandemic, virtual meetings, as you know, have been declared by the state of Iowa to be the same as in-person meetings. And I say that because in-person is used in the next paragraph that I'm going to discuss. In the March 2016 Iowa Supreme Court decision of Hutchison versus Shull, a proxy was used by the county leaders to, quote, facilitate discussion among themselves, negotiate an agreement as evidenced by the fact that the board never discussed the plan at an open meeting before they actually implemented it. In this instance, the Board of Regents used their executive director as a proxy to facilitate, negotiate an agreement, and implement a plan when they made the announcement on August 21st for the University of Iowa Athletic Department budget before it was ever discussed in any open meeting. The Supreme Court also found that, quote, the open meetings law does prohibit the majority of a governmental body gathering in person through the use of agents or proxies to deliberate any matter within the scope of its policy-making duty outside the public view. The open meetings law is intended to safeguard free and open democracy by ensuring the government does not unnecessarily conduct its business in secret.
Ms. Howards?
From the Supreme Court.
Ms. Howards, that's been 5 minutes.
This business by the Regents was unnecessarily conducted in secret.
Ms.
The
Howards?
executive director.
That's been 5 minutes.
Okay, can I conclude?
Yes, please conclude.
Okay. This business was unnecessarily conducted in secret. The executive director and regent members could have asked the athletic director to bring his budget plans to the scheduled September board meeting. They could have called a special meeting where this very complicated situation that involves over 125 million public university dollars and nearly 700 student athletes, it could have been presented and discussed in open session. Instead, a decision was made to approve, and implement a budget for which the Board of Regents is legally responsible in this series of meetings and phone calls, using that executive director as a proxy. This doesn't meet any of the requirements of an open meeting in which a decision is made and implemented, such as public notice, published agenda, open session voting, keeping of minutes. I'll summarize. You can read my last couple paragraphs, but I'm asking you if you would please void this decision and require the Board of Regents to have the athletic director clarify and show his plan, the budget concerns in public session and with all the information before a decision is made. Thank you very much for your time.
Thank you. And we have a representative from the Board of Regents who was on the line. Would you care to speak as well?
I would. Thank you, Madam Chair. Amy Clays on behalf of the Board of Regents. But before I get into my remarks, I think it bears emphasizing that, as noted in Executive Director Johnson's comments and her proposed dismissal order, the athletics budgets were considered by the Board of Regents in a public meeting that was live streamed. The audio and video is still on YouTube if anybody would like to link and access that. So just to be crystal clear, the athletics budgets were considered in a properly noticed public meeting. In Ms. Horwath's written and verbal comments, she raises a number of issues, many of which are simply beyond the jurisdiction of the Iowa Public Information Board or are not particularly relevant to the dismissal recommendation. I'm just going to respond to a couple of points, but I would be happy to answer any questions you have on any of the other comments that Ms. Horwath made. As Executive Director Johnson mentioned in her opening remarks, a meeting of a public body is subject to the requirements of Chapter 21 only when there is both a gathering of a majority of the members and deliberation or action. As evidenced by the affidavit submitted by each of the 9 members of the Board of Regents and its Executive Director, neither of these requirements have been satisfied. At most, as Ms. Horwath mentioned, 3 members of the Board of Regents participated in a conference call with University of Iowa staff to receive information regarding athletics matters. Approximately 2 weeks later, the president of the university phoned each board member individually simply to inform them that he had made the decision to eliminate 4 varsity sports. At no point in time did a majority of the members of the Board of Regents gather to deliberate or take action upon the president's decision. Nor did they have to, as Executive Director Johnson mentioned, because this is a matter that has been delegated to the president. Ms. Horwath now alleges in her response to the dismissal order that over the course of the calls described in the affidavit, the Board of Regents used the Executive Director either as an agent or proxy to improperly negotiate and implement a plan for the athletics budget. This is simply not the case, and it is not supported by the affidavits, which again have been submitted under the penalty of perjury. The Executive Director participated in these calls as an employee of the board, not as an agent for any individual board member. Further, during each of the calls described in the affidavit, board members only received information. There was simply no deliberation or action by any members of the Board of Regents. As a result, the holding in Hutchinson v. Scholl is simply inapplicable to the present matter. I think it's worth emphasizing, too, that in Hutchinson v. Scholl, the Supreme Court reaffirmed that it is not a violation of the Iowa Open Meetings Act for members of public bodies to meet with staff members to receive information. Finally, I'm going to address Ms. Horwath's remarks concerning the Board of Regents' statutory responsibilities. As noted in Executive Director Johnson's proposed dismissal, 262 is beyond the jurisdiction of the Iowa Public Information Board. Now, that being said, and without conceding jurisdiction, the legislature has vested with the Board of Regents explicit authority to delegate its statutory responsibilities to the administrative officials within the institutions under its jurisdiction. And for reference, that authority can be found at Iowa Code Section 262.12. Ultimately, the Board of Regents fully supports the proposed dismissal order and respectfully requests that it be adopted. I would be happy to answer any questions you might have.
Well, then let's go to board comments. People can address any questions they have for the complainant or the Board of Regents representatives at that time.
Joan.
Well, while I don't know how I feel exactly about the recommendation to not accept. I mean, technically, on the grounds of not having had a majority present meeting, that's technically. I mean, that's the case. That appears to be the case anyway. I guess my only concern, and I also know that in all kinds of public meetings, people subject to open meeting laws, municipalities and school boards, it's not unusual for a leader to meet with a small group if it's a committee moving forward on something. But I guess I would say it's not probably the cleanest process in something that needs to be in the light of day, to have a small group meeting. If the individual calls were informing of the decision already, I guess that seems like that is what it is, and I believe that. The difficulty and the muddiness of it for me a little bit of mud, not a lot of mud, but just a little bit, could be that in small groups you can have the appearance of trying to reach some consensus. So that's about all I have to say. Thank you.
EJ?
I guess without repeating what Joan said, I have the same discomfort. It's when I read this, it looked a lot like the walking quorum issue, I guess. But as I understand it, Margaret, and I was trying to find it in your report, but it's the president has the authority to make these decisions. Is that correct?
Yes, EJ, yes, that is correct. It's in Iowa Code Chapter 262.
I remember seeing it. I was just trying to find it in my report as I was listening and reading it.
Yeah, it's a footnote.
But anyway, the other thing is we don't have jurisdiction. Is that clear? I mean, does 262, do I understand 262 prohibits us from handling this? Maybe I didn't understand what was in the report or what was said.
I think that to the extent that this is Margaret, to the extent that there is a concern that the Board of Regents are not properly handling their duties in allowing the president of the university to make a decision as to which sports to eliminate or modify or whatever, that statute, that policy is not within our jurisdiction. That delegation.
Okay, well, I understand. Okay, I understand it better now. Okay, well, I guess bottom line is I would reluctantly concur with the conclusion here of dismissal, but it looks like I could have been handled a little more transparency. Thank you.
Keith? Keith?
I would adopt the previous comments. Thank you.
Monica?
I agree with what was said prior. That's all I have.
Rick?
Yeah, I'll join with the discomfort of the previous board members. It looks like a form of walking quorum, which, while we don't approve of those, it's not in violation of the law, in my opinion.
Julie?
It would have been nice if instead of calling individual members the decision and its rationale had been announced at a meeting that everyone could hear. It reminds me of a complaint we had some months ago about the manner in which the Board of Corrections, I think, selected their next director. And I don't think there's a technical violation of the open meetings law, but I understand why people are upset. And it would have been preferable had they chosen to have an open session discussion, because it affects the serious decision that affects a lot of people. So with disappointment and some degree of annoyance, I would concur there's no violation.
Susan.
I don't have anything to add. I think we've had quite a really good comment.
Stan.
No comment.
Okay, Julie.
This is Amy Hovers. Am I able to interject another thought before a vote is made?
I don't think that would be helpful at this point. I'd like to go on to ask for a board motion.
Well, can I say what I want to say before we decide whether it's helpful or not?
Well, we gave you 5 minutes.
Clarify something.
Go ahead.
But the question that I think I can answer.
Go ahead.
Okay. The question was asked about the code 262. I brought that up merely to show that the Board of Regents is in charge of that athletic department budget. And the difference between what we're talking about here and what we're talking about with the walking quorum, it may seem subtle, but it's very important. And the difference is a walking quorum is a discussion. This was not simply a discussion. It was a decision. The decision was made and implemented before there was ever a meeting. The decision was announced and implemented on August 21st. The meeting was not until September 23rd.
Thank you for the clarification.
Thank you.
Do we have a motion from the board?
This is EJ.
This is Monica.
Wait a minute.
I'm sorry.
You're moving the dismissal order, EJ?
Yes.
Okay. Monica?
I will second it reluctantly.
Okay. Moved by EJ, reluctantly seconded by Monica. Roll call vote.
Corbin.
Aye.
Giovanetti.
Aye.
Lochtel.
Aye.
McHugh.
Aye.
Marine.
Aye.
Podorf.
Aye.
Stewart.
Aye.
Thompson.
Abstain.
Okay, Julie, that's 7-0 with 1 abstention.
Okay, the dismissal order is approved. The next item on the agenda, Nate Jones, the Iowa Department of Public Health. Margaret?
Yes, this is case number 20FC0086, Nate Jones in the Iowa Department of Public Health. This complaint was filed on August 27, 2020, alleging a violation of Chapter 22. He included a copy of the request that he made on August 20th, 2020 to DPH, Department of Public Health, asking for, and this is what he actually asked for, all documents in the Iowa Department of Health's possession related to or mentioning the testing of the Agri-Star meat and poultry plant in May 2020 for COVID-19, including for active and prior cases through PCR testing, serology, and other methods. In response, he received a response saying that Iowa Code Section 139A.3 sub 2 sub B and Iowa Code Section 22.7 sub 16 prohibited those records were confidential. He asked that we determine whether or not Iowa Code Section 139A.3 sub 2 sub B was properly interpreted and to release any information that should be released pursuant to Iowa Code Section 139A, sub point 3, sub 2, sub B. He made a reference to Iowa Code Section 22.716 in his complaint, but did not request us to review specifically that subsection. However, I have included that in the dismissal order. We do not have the ability to determine whether or not the Department of Public Health has complied with Iowa Code Chapter 139A. However, 22.716 requires that certain DPH records be kept confidential. And it says information in a report to the Iowa Department of Public Health, to a local board of health, or to a local health department which identifies a person infected with a reportable disease. The testing results would clearly identify the individual tested. So while they can provide aggregate numbers and summaries of numbers, which they are currently doing on their Iowa coronavirus website, they are not able, the underlying test documentation is actually confidential under Iowa Code. So that's the reason for my recommendation of a dismissal as legally insufficient.
Okay, we need somebody to mute their phone again. We're getting background noise. Margaret, go ahead.
That's all I had.
I'm getting an echo.
Please mute your phones.
Is the echo because they're not muted?
Most likely.
All right, thank you. Do we have either Mr. Jones or somebody from the Department of Health on the line? Not, let's go to board comment.
Joan?
No comment.
EJ?
No comment.
Keith?
No comment.
Monica?
No comment.
Rick?
No comment.
Julie?
Nothing from me.
Susan?
No comment.
Stan?
No comment.
Okay, can we have a motion on the dismissal order?
This is Rick. I'll move to dismiss.
This is Joan. I would second Monica.
Okay, moved by Rick, seconded by Joan. Roll call vote.
Corbin?
Aye.
Giovanetti?
Aye.
Luchtel?
Aye.
McHugh?
Aye.
Moraine?
Aye.
Podorf?
Aye.
Stewart?
Aye.
Thompson?
Aye.
Julie, that's 8 votes in favor and 0 against.
Okay, the dismissal order is approved. Next item on our agenda is Kevin Kilgore and the Ringgold County case.
Yes, this is case number 20FC0094. It involves Kevin Kilgore and Ringgold County as respondent. This complaint was filed on September 14th, alleging that there's a violation of Iowa Code Chapters 21 and 22 because there was the monthly reports from the treasurer and auditor are not posted on the county website. The Board of Supervisors chair signs and approves and signs meeting minutes despite his absence at the meeting, and the posting of meeting minutes on the county website contained a contradicting signature. He said that the failure to post the county treasurer and auditor reports online constitute violations of various provisions of Iowa Code Chapters 349 and 372. In fact, there were not any violations of Iowa Code Chapters 21 or 22 included. Subsequent to the filing of the formal complaint, he actually filed 13 addendums. There are 10 that are listed here, and then after this order was issued on October 8th, he filed 3 more, one actually this morning. But so on October 8th, 11th, and 14th. None of those addendums had any relevant information to a violation of chapters 21 or 22. So at this point in time, it's not only legally insufficient, there is no merit to his complaint or the addendums.
Okay, do we have Mr. Kilgore or someone from Ringgold County on the line? Nope. Let's go to board comment.
Joan?
No comment.
EJ?
No comment.
Keith?
No comment.
Monica?
No comment.
Rick?
No comment.
Julie?
Nothing further.
Susan?
No comment.
Stan?
No comment.
Okay, can I have a motion to approve the dismissal order?
Keith, also
I move that we. I'll second that.
Okay, moved by Keith.
Either way, I don't care.
Moved by Keith, seconded by Monica. Roll call vote.
Corbin?
Aye.
Giovanetti?
Aye.
Luchtel?
Aye.
McHugh?
Aye.
Moraine?
Aye.
Potter?
Aye.
Stewart?
Aye.
Thompson?
Aye.
Julie, that's 8-0.
Okay, the dismissal order is approved. The next item on the agenda is Nicholas Korleski, City of Sioux City. Margaret?
Yes, this is case number 20FC0100, filed by Nicholas Korleski and involving the City of Sioux City. He filed the complaint on September 29th. He alleged a violation of Iowa Code Chapter 22 on July 15th. He provided a copy of a record or a letter he got on July 15th, 2020. He had requested an unedited copy of a police officer's quote complaint allegations record. He was denied that in a letter dated July 15th. The reason for the denial was that the record was confidential pursuant to Iowa Code Sections 22.7 sub 4 and 22.7 sub 11. The city provided the information that was to be released by Iowa Code Section 22.711A1 through 5 in the July 15, 2020 letter. In response, legal counsel said 22.7 sub 4 was applicable because internal affairs records are conducted by, or actually investigations are conducted by the city's legal department specifically to address potential litigation. And in addition to that, 22.7 sub 11 requires the release of certain personal information, but the remainder is confidential. So they released what was not confidential. Also noted that according to Iowa Code Section 23.7 sub 1, we have a 60-day statute of limitations that requires a complaint be filed within 60 days of the date of the allegation. The allegation was July 15th. This complaint was filed on September 29th, more than 60 days later. We do not have jurisdiction to proceed further with this complaint.
Okay, do we have either Mr. Korleski or someone from Sioux City on the line? Let's move to board comment.
Joan?
No comment.
EJ?
None.
Keith?
No comment.
Monica?
No comment.
Rick?
No comment.
Julie?
Nothing further.
Susan?
No comment.
Stan?
No comment.
We have a motion to approve the dismissal report.
This is Monica. I'll move that we accept the dismissal order.
Okay. Second.
This is Joan. I would second.
Okay, moved by Monica, seconded by Joan. Roll call vote.
Corbin.
Aye.
Giovanetti.
Aye.
Lochtel.
Aye.
McHugh.
Aye.
Moraine.
Aye.
Podorf.
Aye.
Stewart.
Aye.
Thompson.
Aye.
Julie, that's 8-0.
Okay, the dismissal order is approved. The next item on the agenda is a report concerning Jean Lewis, the Jasper County Board of Health.
Yes, this is case number 20 FC0075, Jean Lewis and the Jasper County Board of Health. This complaint was filed on July 16th. The board accepted the complaint on August 20th. And the parties have proposed and approved an informal resolution as indicated in the report provided by Brett. Right now, the terms should be completed within 90 days of acceptance by all parties, and once we've got proof of compliance, it can be dismissed and successfully resolved. The recommendation is that the IPIB approve the proposed informal resolution, direct the IPIB chair to sign the informal resolution, set the matter for compliance review in accordance with the terms of the informal resolution. And Mr. Torsdahl is available to answer any questions that board members might have about the negotiations.
Are either Jean Lewis or someone from Jasper County on the line? Let's go to board comment and any questions for Brett.
Joan.
No comment.
EJ.
No comment.
Keith.
No comment.
Monica.
No comment.
Rick.
No comment.
Julie.
Nothing further.
Susan.
No comment.
Stan.
No comment.
Okay, can we have a motion to accept the informal resolution report?
This is Joan. I would move to accept the informal resolution report.
This is Stan. I'll second.
Moved by Joan and seconded by Stan. Roll call vote.
Corbin.
Aye.
Giovanetti.
Aye.
Lochtel.
Aye.
McHugh.
Aye.
Moraine.
Aye.
Podorf.
Aye.
Stewart.
Aye.
Thompson.
Aye.
Julie, that's 8 votes in favor and 0 against.
Okay, the report is accepted.
And I would add, Julie, if I may, I just looking at emails while we've been meeting, and I got word from Jasper County Board of Health that they've completed their training already. So
Oh, that was fast.
we
Okay.
should have the final. Might be ready next month.
Okay, the next item on the agenda is another Jean Lewis and Jasper County Board of Health matter.
This is case number 20FC0092. Jean Lewis, again, and the Jasper County Board of Health has responded to this comes before you as a dismissal order. This complaint was filed on September 4th, alleging that there was a violation of Iowa Code Chapter 22. On August 24th, she made an open records request for a recording of a board meeting that occurred on August 6th from the office coordinator for the board. She alleged that the board coordinator told her to pick up a copy of the recording on an external flash drive, download it to her computer, and return the flash drive to the board. She said she was unwilling to do this due to security concerns with using the board's flash drive. She alleged, in addition, that the failure to post the recording to its website also violated Chapter 22, and she wanted us to require the board to post all recordings and copies of the minutes to its website. Legal counsel responded, stated that the board has a copy available for Ms. Lewis, or she could review the recording in person if she wants to. the board does not have any the technological means to upload and post the recordings to its website. She indicated that she refuses to do that. Chapter 22 does not require a government body acquire a website or post certain recordings on a website that it has. The records are available for her to review, or if she wants to bring her own recording or storage device, they'll copy the recording for her. At this point in time, my recommendation is dismissed as legally insufficient.
And since Jean Lewis was not on the line for the previous complaint, I assume they still aren't, and no one from the Jasper County Board of Health. We'll move ahead to board comment.
Joan?
No comment.
EJ?
No comment.
Keith?
No comment.
Monica?
No comment.
Rick?
No comment.
Julie?
No comment.
Susan?
No comment.
Stuart, or Stan?
No comment.
Okay. Can we have a motion to approve the dismissal order?
Keith, so moved.
Second.
Okay, moved by Keith, seconded by Susan. Roll call vote.
Corbin?
Aye.
Giovanetti?
Aye.
Lockle?
Aye.
McHugh?
Aye.
Moraine?
Aye.
Potterf?
Aye.
Stewart?
Aye.
Thompson?
Aye.
Julie, that's 8-0.
Okay, the dismissal order is approved. The next item on the agenda, deja vu, Jean Lewis and the Jasper County Board of Health. Margaret?
Yes, this is case number 20FC0093, filed on September 9th. Ms. Lewis alleged that the Jasper County Board of Health had violated Iowa Code Chapter 21. She alleged on September 9th. They've not yet posted a copy of the agenda for the board meeting scheduled for September 10th within 24 hours of the meeting. On September 11th, the Jasper County Attorney filed a response. He noted that the public notice and agenda were properly posted in the County Health Department office, which is the principal office of the body holding the meeting as required by Iowa Code. He also noted that even though not required, there was a notice and agenda posted on Jasper County website on September 4th, and an amended agenda was posted on September 8th. Both postings were more than 24 hours prior to the meeting. He provided a copy of the posting on the office bulletin board. Ms. Lewis indicated that publishing the notice at the county health was not sufficient in her opinion. At the very least, the agendas should be posted at the Jasper County Courthouse and the public library, and etc. However, the notices were appropriate and adequate under the code, and at this point in time, it's legally insufficient and recommending dismissal.
Once again, neither Jean Lewis nor anybody from the Jasper County Board of Health are on the line. We'll move on to board comment.
Joan?
So, Margaret, I'm understanding that the angst or the complainant is concerned with both the lack of 24 hours notice, but your assertion is that that didn't happen. It was adequate, correct?
Yes, there was something wrong with the notice. All of this was kind of going along at the same time, or just prior to when we were dealing with the very first complaint that then we were able to we accepted, and she still wanted these to be brought before the board rather than withdraw.
Gotcha. Okay. Okay. Thank you. No further.
EJ?
Nothing.
Keith?
Nothing.
Monica?
No comment.
Rick?
No comment.
Julie?
Nothing from me.
Susan?
Nothing from me.
Stan?
No comment.
Okay. Can we have a motion to accept the dismissal order?
This is EJ. I'll
This is
move.
Monica. This is Monica. I'll second.
Okay, moved by EJ, seconded by Monica. Roll call vote.
Corbin?
Aye.
Giovanetti?
Aye.
Luchtel?
Aye.
McHugh?
Aye.
Moraine?
Aye.
Podorf?
Aye.
Stewart?
Aye.
Thompson?
Aye.
Julie, that's 8 in favor and 0 against.
Okay. Dismissal order is approved. The next item on the agenda is Jerry Peck in the City of Zering, a final report. Margaret?
Yes, this final report was actually prepared by Zach, but I'm going to present it in his absence. It's 2 case numbers, 20FC0011 and 20FC0014. The terms of the informal resolution were adopted on May 21st. They've now been successfully completed, and we're asking to dismiss both complaints. And you'll see that there's actually a final report that Zach has had prepared that provides more details. But basically, they're finished, and we just need to dismiss it.
Either Mr. Peck or someone from the City of Zering cares to comment. Wait, either are on the line. Let's go to board comments.
Joan?
No comment.
EJ?
No, no comment.
Keith?
No comment.
Monica?
No comment.
Rick?
No comment.
Julie?
Nothing.
Susan?
No comment.
Stan?
No comment.
Okay, can we have a motion to adopt the final report and dismiss the complaint?
This is Monica. I move that we accept the final report.
And dismiss the complaint.
Yes, and dismiss the complaints.
A second?
Keith, I'll second.
Second, Susan.
All right. Moved by Monica, seconded by Keith. Roll call vote.
Yeah.
Corbin?
Aye.
Giovanetti?
Aye.
Luchtel?
Aye.
McHugh?
Aye.
Moraine?
Aye.
Podorf?
Aye.
Stewart?
Aye.
Thompson?
Abstain.
Julie, that's 7 in favor with 1 abstention.
Okay, final report is approved and the complaints are dismissed. The next item on the agenda is Jamie Simpson and the City of Essex City Council, a final report. Margaret?
Yes, this comes before you on review of compliance on an informal resolution, and the terms have been completed as outlined by the report submitted by Brett Torsa. Just ask that you dismiss the complaint as resolved.
And I are either Mr. Jamie Simpson. I'm getting all kinds of echo again. Okay. Echo seems to have quieted down. Are either Jamie Simpson or someone from the Essex City Council on the line? Let's go to board comment then.
Joan?
No comment.
EJ?
No, no comment.
Keith?
No comment.
Monica?
No comment.
Rick?
No comment.
Julie?
No comment.
Susan?
No comment.
Stan?
No comment.
You know, not to be a complainer, but I'm still getting echoes of whatever people say. Is that because a line isn't muted that should be? Or am I just losing my mind here?
No, Julie, we can hear it here as well.
The next item, the last one under section 5 is
Julie?
Alex Jacobson.
Julie?
Yeah.
You need to get a motion on the Simpson.
All right. The echo distracted me. Do we have a motion on the Simpson matter to adopt the final report?
I would move to dismiss this complaint as resolved, and this is Joan.
This is EJ, I'll
This is
second.
Stan, I'll second.
All right. Moved by Monica. Was that Joan? Joan. Seconded by EJ. Roll call vote.
Corbin?
Aye.
Giovanetti?
Aye.
Lochtel?
Aye.
McHugh?
Aye.
Moraine?
Aye.
Podorf?
Aye.
Stewart?
Aye.
Thompson?
Aye.
Julie, that's 8-0.
Okay. Then the final report is adopted. Now we're on to Mr. Jacobson and the Ames Community School District. Margaret?
Yes, and you should have, I sent out a comment that was made by Mr. Jacobson. He sent that in on Sunday, so I think I sent it out the next day to you all. But this dismissal order is 20 FC 0072, Alex Jacobson and the Ames Community School District. This is the third time that this has been on the agenda. The first two times Mr. Jacobson had asked for it to be continued. So this is the only changes that have been made and during that period of time is just to change the date of the meeting that this would be reviewed at and to change the date of the certificate of mailing. But basically he asked for a copy of the following records, and he asked for this on June 30th. He was asking for electronic record of security protocols and prevent federal worker get assessment and detailed results her own child. So it appeared, and nobody has disputed this, so what he was asking for was some testing protocols and also some educational records relating to his own child. In response, the district indicated that the records Mr. Jacobson needs concerning his educational records are not public records, but are available to him as a parent, and that the test protocol records are confidential records pursuant to Iowa Code Section 22.7 sub 3 as trade secrets, and 22.7 sub 19, which says examinations when the release of such could interfere with the accomplishment of objectives for which they are administered. So as noted in the italic area in the response from the school district, test protocols are not disclosed because they ensure that the validity of the testing results and they maintain test security. So that is why they are specifically not allowed to be disclosed and are considered confidential records under Iowa code. And in addition, on the second page, you'll note that there's actually even some Iowa court law that specifically says that these protocols are not public records. So there is a discussion as to whether or not they're trade secrets. However, I think it's very clear under 22.7 sub 19 that whether they're trade secrets or not, they are confidential pursuant to that section, to 22.719. So I'm recommending that we dismiss this as legally insufficient.
Mr. Jakobson or someone from the Ames Community School District on the phone? Apparently not. Let's go to board comment.
Joan?
Margaret, question I have, you had said that this is just the same, similar, or the same but a different date or whatever. So and I did read his commentary in the email that you sent. So he just wants reconsideration?
No, I had proposed this as a dismissal order based on the same grounds.
Right.
Just exactly like this.
Okay.
For the first time in August. Okay. He wanted more time because he was waiting for some records he was going to get from the Department of Education at the federal level.
Gotcha.
And then in September, he hadn't gotten them yet, and he anticipated getting them in September 22nd.
Just a continuance. Okay.
Yeah. So,
all right, very good. Thank you. Thanks.
Yeah.
Yep, thanks for your help.
EJ?
No comment.
Keith?
No comment.
Monica?
No comment.
Rick?
No comment.
Julie?
Nothing from me.
Susan?
Nothing from me.
Stan?
No comment.
Do we have a motion to accept the dismissal order in the Jakobson matter?
This is Monica. I move that we accept the dismissal order.
Okay, and a second.
Keith, I'll second.
Okay, moved by Monica, seconded by Keith. Roll call vote.
Corbin?
Aye.
Giovanetti?
Aye.
Luchtel?
Aye.
McHugh?
Aye.
Rain?
Aye.
Podorf?
Aye.
Stewart?
Aye.
Thompson?
Aye.
Julie, that's 8 in favor and 0 against.
Okay, the dismissal order is approved. Let's move on to Section 6, matters withdrawn with no action necessary. You want to just summarize these two for us, Margaret?
Basically, the Carlson one, she had just asked what the purpose of one of the closed sessions was with Davenport, and then she was satisfied when they told her what it was.
Oh, okay.
Yeah, and then the other one, Iowa Live, they actually got the records, and so then they, I'd actually drafted a dismissal because he didn't ask for records. He or she, they had questions, and meanwhile they had been answered. But when I issued just before I sent out the dismissal order, they sent me an email saying that they were withdrawing the complaint. So that's all I know about
Then
those.
you don't need votes from us on those, evidently.
No, we don't.
Pending complaints, the listed for us here.
Yeah.
Sound of my cat meowing in the background.
Some of them, just to give you an idea, intake means that we just got it and we don't have all the information back in order to present an order to the board. Pending means it's been accepted in the past and still either working out the terms of an informal resolution, or there's been an informal resolution adopted, and we're just waiting for the time for them to finish compliance. So that's kind of what pending means.
Okay. Committee reports.
Do you want me to give an update?
Yeah, that'd be good.
Okay. Communications. We've actually, because there's been a lot of confusion on this, on people asking us a question or submitting an advisory report or advisory request, we're going to, that's going to be modified on our page so that people can ask a question, or if they meet the actual guidelines for filing for advisory opinion, then we'll have a different link for them to do that. And then Brett got a Katska thing on our website, so we're not getting spam anymore. We got some pretty unique spam. I gotta admit, probably would have been really dangerous for us to log onto it, but I think that's pretty much all we've got right now in communication.
Legislative committee?
Bill drafts have been filed. I went to them or attended the virtual class on how a bill becomes a law in Iowa, and they told us that we should have, within a day or two after you draft and submit your drafts, that you get assigned a bill person. So it'd been 2 weeks and I hadn't gotten any. So I called, and apparently I'm the only person that submitted bills so far. And they were hiring people that were going to start tomorrow. So possibly in the next week or so, I'll have an idea who's going to be our bill drafters, but they're going to be new people with no experience.
Okay. And rules.
If you want to do that one, Julie.
Well, I can. We're still wrestling with the metadata issues, which are more complex than you'd think. But Margaret did find somebody in state government who was very helpful at telling us the kind of data that's present in metadata and what can happen if you forward an email with metadata attached. The difficulties and software demands of not only you can redact the message, but then how do you handle redacting the metadata? When can it be undone to undo the redactions? And the complexities that kind of happen if you have to have software to redact the metadata as well. So on the one hand, we have people who think this is a very simple issue and that the statute is clear that they're entitled to the emails to just be forwarded to them because they regard readily accessible as meaning you can pull it up on your screen and hit forward and send it on. And people like Mr. Kinney, who is our helpful expert here about what some of the complexities are of trying to, what people can find out from metadata that you may not anticipate. We still need to hear, I want to hear from someone from law enforcement because they have particular concerns about what might happen with metadata if they have records that are regarded as public. So I don't think we're close to making a decision about what to do, if anything, and it might ultimately be a legislative recommendation as far as rules are concerned. We also talked about a minor rule change to make sure that the executive director is authorized to delegate preparation of advisory opinions staff in exec right now. And I think that's a fairly minor adjustment to the rule. And some other rulemaking topics. Yeah.
This is Monica. I just have one question, and I'm hoping it's a yes or no answer. On the metadata on an email, does every email have metadata attached to it?
I believe the answer is yes.
I can answer that as well, too. Actually, this is Margaret. This is cool because this is something that Steve showed me or told me about, and so I've been doing it all the time now. But if you're on an email or you're on a web page or any number of anything on electronic, and you right-click, and there's a link on that. When you right-click, you can see View Sources. You click on View Sources, and you're going to see the metadata. It is amazing. So
I've done that before. Okay, I didn't. Okay, I get it. I did not realize that was considered metadata.
Yeah. If you're the request that originally generated this discussion by Mr. Gerdevoy, who wanted records from the U of I, all of the records he was requesting were public and didn't require redaction. And if you recall, in the end, the U of I just agreed to give it to him in electronic form.
Right.
But if you have to redact the message and you're just printing it off and blacking it out, that's fairly easily done. But if the metadata goes with it, some of the things Mr. Kinney explained you could find out would be the geolocation of the person who sent it.
Oh.
You can undo redactions, which would undo any protection that's required by law be taken out. You can see earlier version drafts. And under the public records law, earlier drafts might not yet be public record. It might be treated as confidential. So there's kind of a trove of information that if you have the skill, you could access the metadata and find out. So I think rulemaking on this is complex.
There is actually...
And I would be interested...
Thank you.
I would be interested in hearing from Keith. It strikes me that Chapter 22 has been around for a really long time, back when people wrote letters on paper. And, the concept of metadata really was not anything anyone thought about. I'd be curious to hear from people like Keith, who've been around for a long time, and just, sorry, Keith, who have been involved in the legislative process for a while, and, and just know what, and try to figure out what the legislature really anticipated when it drafted some of these provisions. They are so far afield from the original, and even the more recent Chapter 22, that I think we need to talk about those kinds of things as well.
Yeah,
Julie, this is Joan. Oh, sorry. Go ahead.
Keith was going to answer Susan's question.
Okay, sorry, Keith.
I don't think that if there was metadata back in those days, I don't think anybody knew about it. And I've always looked at that as it developed as not really part of the public record. It's not a record that's used by the public entities to make decisions or exercise orders or authority or whatever. And so to me, if you make public or allow access to metadata, I think you're going a step beyond what was ever contemplated by the legislature. And maybe they would do that, but I don't think that that's the intent that's in the law now.
The way the statute's written, I can see why Mr. Gerdevoy and maybe others think that it's pretty clear. You can just get it, the email's accessible to the lawful custodian, and you could just forward it. That's what the statute requires. But I think you're right that they didn't anticipate that means you get all this background information, you could undo redactions, you could find out where the sender is.
See, I think my real conclusion is that the bottom line is that the metadata is not part of the public record.
There's some cases that he cited that do treat it as public record, but many of them come up in the context of discovery. And I could see why in a litigation case you'd have to turn everything over, the email and the metadata, and that would all be accessible. But that's a very different context than making a record available in response to a public records request. So I'm particularly worried. I'm worried practically about very small towns, small counties, where they don't have the technology you'd need to redact metadata as well, and may not realize they're passing on the ability to undo redactions or find out information about the sender that may be protected. So it's much more complicated than just saying if you can pull up an email and forward it, then they're entitled to it in electronic form.
And I think the devil's advocate to Keith, there are, I can't remember what section it is, but there's a relatively long section about data processing software. So, it's not like it hasn't been updated to recognize people use computers these days. So, it's an interesting question.
Yeah, I'm pretty certain that when that was enacted that we didn't contemplate metadata.
And I'm worried practically that it's beyond the technical capability of some small towns and even small counties to redact metadata. And you don't want them sending something on redacted in the message that can be undone. Confidential information gets disclosed inadvertently. So I want to hear more from law enforcement people and their particular concerns, but the Rules Committee may wind up just recommending as a legislative change to do something different with this, so people in Mr. Gerdevoy's spot may not automatically get a record forwarded. And the custodian should realize when they do forward a record, forward an email in electronic form, all kinds of other information goes with it.
This is Margaret again. Just as an aside, because now I'm all into this metadata stuff, but a couple of weeks ago, there were some pictures that were sent out showing an elected official who was hospitalized doing work. And, like in the scenes, they were in two different rooms, one time he had his jacket on, one time he didn't. And they were able to use the metadata to determine they were both taken by the same camera within 5 minutes of each other. At the same general location. It wasn't specific enough to show that, that the individual had changed rooms. But they were able to show from the metadata exactly what time those photos were taken, which I thought was interesting.
So I guess for the Rules Committee, we're going to do still some more looking, but we may or may not wind up with any rules and may or may not wind up with a legislative suggestion. That law has been in effect since 2015, but Mr. Gerdevoy's request is the only one I recall of anybody wanting it in electronic form, citing that law, that authority. So we may have bitten off more than we can chew, taking this up in rules. We've looked at a couple of other topics being considered for rulemaking, including whether it's wise to use rules to define when a complainant could have become aware of a violation in terms of the timing. If you have 60 or 90 days to file, it might be a different timeline if you could have been aware based on specific facts. But I think it's so factual specific that a rule would be of limited utility, and you'd have to decide on a case-by-case basis. Similarly, we talked briefly about whether to try to define expenses that may be incurred and what's a reasonable fee in terms of the cost of getting public records. But I think the ultimate guidance by the statute is actual cost, and I'm not sure how helpful the rules would be in elucidating what the expenses and reasonable fees mean. And then finally, we looked briefly, and we're going to come back to it, on whether to do a rule interpreting the release of utility records under the utility chapters. And Susan raised an advisory opinion written by Heath some time ago, and some confusion as to when utility records are accessible and when they're not. That also may be beyond what a Rules Committee can do, but we're going to review Heath's advisory opinion and decide whether there are further rules that we can do that would help, or whether it needs to be handled legislatively by the utilities themselves. If either Susan or Joan have something to add about the Rules Committee, feel free to do so.
This is Joan. I was just going to mention that one of the things that was brought out that kind of falls into what is easy to access, the readily accessible or whatever, was brought out that when you're not forwarding in an email any of the hyperlinks that would allow you to better understand that material by providing background information or analytics, is missing in the copied off form. So either there needs to be a workaround for that. If we can't, if you can't forward it on is there some other way to provide it? Although it sounds pretty cumbersome for a municipality or entity to have to, provide paper contact of all of the hyperlinks. It just goes to show we're still like 1 foot in one world and 1 foot in digital world, and not everything's figured out, I think.
That was a
That's all I
legitimate
have.
concern. That's a legitimate concern that Mr. Gerdevoy raised. The links are useless if you don't have an electronic version.
Right.
One thing we might take up in another meeting, I'm wondering, and I didn't think of it to ask Mr. Kenny at the time, is whether metadata can just be severed from the message itself. So that if you're going to forward a message on, you send the message and you don't get into the whole murky world of forwarding on metadata. But I don't know if that's possible. It would solve a lot of problems.
This is Monica. I'm thinking here and thinking outside the box. If you go to forward a message, and so you print it as a PDF file and then forward that PDF file, I'm assuming that the metadata does not follow that, correct?
That's correct.
Yeah.
Okay.
Well, the PDF wouldn't have any metadata, just your forwarding of it would have its own metadata attached.
Yeah.
Right, but if you were trying to forward emails, you can forward those, or you could actually print those and save as a PDF and send it that way, and then you'll avoid the whole metadata issue.
But then you're back in the problem that any
That
links
was Gervois'
don't work
issue.
because it's a PDF.
Well, also
I guess they have to learn how to type very long links. Because you can turn those into, granted in a PDF, they can be hidden, but the other part of it is you can also turn those into the actual link. Yes, you would have to type it. But, I mean, there's an option.
You mean the web address for the link?
Yeah.
Instead of a click here, you just see the web address. That's an idea.
Right. And you can copy and paste that from a PDF file.
I recognize links are subject to change, so you could have a link, and in a minute later I could take stuff out of that link. So, your links are nice, but you're not guaranteed that that's the same material that someone looked at. They originally looked at the email.
That's true. Well, anyway, those are the issues the Rules Committee wrestled with.
I would just, we need to point out that Alexei, I forget his last name, it starts with a G, has been a really good, I think I can speak for myself, I think we've learned a lot about metadata and things like that from him. He's been a very helpful resource. And I would have to say it's his position that no matter how small a community is, they should all be doing the same thing and releasing metadata and using redacting software. So,
but I don't think that's very realistic. Anyway, we have a lot more lawful custodians than have access or the technical ability to use that kind of software. And he did acknowledge, too, the review costs by attorneys would be bigger. They have to review the metadata as well as the substance of the message. Most requesters are not interested in the metadata. They want the substance of the message. Don't have a quarrel with having gotten it in paper form. So it's a complex problem that we don't yet have a solution for. There are no other comments on the Rules Committee. Let's move on to Office Status Report. Margaret?
All right, contacts and activity. We are one count ahead of the end of September last year. So, yeah, I guess that there's not much else to say outside of, there we are. We're staying busy.
Margaret?
Yes.
This is Rick. I'm just glancing at the total for September, for the running total, and maybe my math is wrong, but I think 585. I think there must be a incorrect number up there in the 5 numbers coming down. It looks to me as though those 5 numbers add up to 485 instead of 585, or is my math all screwed up?
If you look under the line of informal resolutions, it says 221. It should be 321. That's a typographical error.
Okay.
Thanks, Rick. And let it be noted that I now understand that board members add up the numbers.
Okay.
Yeah, it wouldn't make sense, I guess, to go from 297 to in cumulative total in August to 221 in September. We don't give them away, but I didn't notice it. Thanks.
We'll put statistics as amended.
Financial budget update, Brett?
Well, given that you read the numbers, the first sheet you see is our financial report, and again, as all months, we're right in line with everything that we've been appropriated, and then how it's being expended as an agency. So unless you have any questions with that, I can move on to the next document.
Okay.
The next document, if you recall last meeting, we're preparing our budget submission for FY22 and FY23. And so we thought, Margaret thought it would be appropriate that you see the actual document that was submitted to the Department of Management prior to the end of September. That put in our request for the next 2 fiscal years. And the base for all agencies, they started with a status quo base. And then we met with the director of the Department of Management to request about 15,000 or 4.4 increase for the next fiscal year, and then another 1.5 or 1.6% for the FY23. And those numbers are simply reflective in the non-personnel side of things, as we took a look at actuals from prior year, just to try and bring those into range and anticipate some increased costs. And if you've heard me talk in the past, many of our non-personnel expenses are really reliant upon other agencies and the money that gets passed through, such as our rents and our computers and things like that. So this will be the budget that goes to the governor for review, and we would anticipate that this request will is appropriate for the governor to pass through to the legislature. Any questions about the budget proposed? And on the budget side of things, we don't have any control over the personnel line. That's preset, and then will be adjusted by the governor and Department of Management as once the contracts have been negotiated with the unions. All right, the last item I wanted to bring up was the issue of per diems. If you remember, a couple months ago we said that since we're doing these electronic meetings, if you want to collect a per diem for this meeting or any of the meetings during this fiscal year, please just send me an email. That way I have a written document that you've requested it. And the simplest thing might be is when you send me your email back to say that you're going to participate in the meeting, just say that you'd also like to collect a per diem for it. And then I make note of it, and it gets submitted through our personal or our HR since it comes out of the salary line. So anyway, and there's no reason you can't go back if you missed a month or something, go back and ask me for that. but just moving forward, just consider that if that's something that you want to do. That's all I have.
Update on district court cases, Margaret.
Okay, the response brief on the Klein appeal to the Supreme Court will be filed tomorrow. Emily had that finished, or had a draft put together, and Zach and I have been helping her get that finished up. So it's due tomorrow, and she's going to file it tomorrow. Rippiger, her response brief was proof brief was due, or is due next week sometime. They've just been really busy over there with a number of other things. Some of them election related, some of them COVID related. So she's going to be requesting 30 days more so that she has a little more time to put some thought into that. So that will probably be due in second or third week, probably third week of November.
I think Randy sent us a district court ruling concerning the body camera footage and a suit filed against Paul Parisic.
That's correct. We did get that, and I think it's gotten some press as well too. I haven't heard, since that's just recently, whether it's going to be appealed. I would imagine it would be, but I don't know for sure.
Which will put it in a timeline, certainly after the submission of the Klein case. For those who read it over, somewhat surprising to me anyway, that the conclusion was that body cam footage is not part of the peace officer investigative report, and so needs to be turned over if there's no exemption for it otherwise. That would be at odds with the outcome in the Burlington case. So the law may be evolving. Presentations and
hey, Julie, this is Monica. When did we get that one from Randy on that body cam with?
It came from me.
Ago?
Yeah, I forwarded it.
Oh, it
Randy
did. Okay.
sent it to me, and I forwarded it.
I'm thinking a week ago.
Oh.
Yeah.
And then it's been on the channel news here as well.
I haven't. Yeah, I haven't watched KCCI. Okay. Yep. No, I see it now. Thank you.
Yeah,
it was interesting because it reached a different conclusion than we would have reached, or we did reach in the Burlington case. So it'll be interesting for us to keep an eye on that. Like Margaret, I expect it'll be appealed.
This is Susan. I found it somewhat chilling. What I think I read in that case was that, as Julie said, they reached a new conclusion about body camera footage, yet they fined the public information person who is responsible for paying attorney's fees.
Yeah, they fined Paul
Parisic.
Yeah.
Whereas I don't see that he would have had any way of knowing that the court was going to reach that resolution. I found that somewhat chilling. I don't think I would ever want to be a public information officer if I knew that to be an outcome. So
Why would anybody want to be a policeman these days?
It was a surprising outcome. As somebody who thinks body cam footage should be available in some cases, I was surprised at that conclusion. It disregarded the Neer case, which was an unpublished Court of Appeals opinion, and reached the opposite conclusion. Not that I think that's a horrible outcome, but it can be a complex outcome in some cases where you have body cam footage and you may have suspects or witnesses who are identified that you don't need to be disclosed or don't want to be disclosed. Anyway, I appreciated Randy sending it on.
Yeah, there was also a line in the case that, at least to me, suggested that the police department or the custodian of the body cam footage would have the discretion to determine, for example, if it had a scene that disclosed, maybe too much personal information and invaded privacy. So it was an interesting case in many respects.
This is Margaret. My thought after reading it was that, if they had already adopted our modifications for 22.7 sub 5, we have the solution to this whole problem. So we just need the legislature to see that as a solution.
Okay, are we ready to move on to presentations and trainings? Margaret?
Last Friday, Zach and I did a CLE presentation with the Bar Association, and I'm still waiting. We're supposed to get a link so that we can put that on our website, which would then allow people that wanted to click on it to see that presentation. But I haven't gotten that back yet. Anyway, Zach did a really good job. I was very proud. He did a very good job, and we got some really good comments after that. The October 13th, that was a group from Tunisia. Instead of physically coming over, they're trying to do these virtually now. So this was a training, or they had me talk to the group about basically about what our board does, how that works, how it was established, and then talking sometime about Vico, and when he was here writing legislation that then he got adopted concerning public records, because they don't have, they're really new democracy, so they don't have a whole lot of laws addressing transparency. So it was interesting. That was kind of fun. So, and then the other two are just coming up. The next one for the Municipal Attorneys Association is on the same date as our November meeting. So Zach will be doing that training. It's not very long. It's like 40 minutes, I think they've got slated. So he's working on putting that together. ISAC, that's the new officers training, the newly elected officers training in January. Any questions on those things?
And do we have a COVID-19 update?
Well, it's still here. The latest word I got is that the new parts and the new doors and electrical stuff or whatever that they're going to install in the Wallace building to have some control over people wandering in and out. That equipment, or those parts are supposed to arrive in the next 2 weeks, and then it'll take somewhere between 2 and 4 weeks to install it. So the building won't open up until all that's done.
And Julie, I'd add to what you said earlier. I'd be curious if board members could respond to you also about when they respond about their interest of doing a video format like a Zoom. You know, do board members have the capability? Would they be comfortable doing it that way? You know, now we're 6-7 months into this, and I think all of us now are starting to have those things a little more frequently, those kinds of meetings. And so, you know, if this board would like to do that format, to be able to see each other during the meetings, raise your hands, you know, we think we could get it set up and make it work. But what we don't want it to do is create a cumbersome meeting for our board as well as the public participation. But, you know, if you would like staff to go to the work to make sure that can happen, if you all would feel more comfortable doing it that way as opposed to conference call, we'd be happy to do it, because we talk about it in staff meeting. All right, this month, how are we going to do this? And I would say the same thing, when we can go in person again, we'll work out the scenarios of how we make sure that we have proper spacing, can get the public included in our meetings, can get the public in our building, and so on. Those are all issues that we can work through as staff, but it would be great to have the direction of the board as to what your preference would be. So.
Well, and for that, I do encourage board members to send me an email. I think we polled people a couple of months ago. My reservation about Zoom is cutting off the public. And while we might get that to work well for board members, I don't want a format that other people are, we've all seen a number of complaints come through where the the public can't participate that way. And the one thing about conference calls is that everybody can get to a phone or has a phone. So let me hear from board members about their preference. Yeah. Yes.
I'm sorry, this is Susan Power Supply. I just wanted to make a note that even if someone doesn't have a computer, they can call in to a Zoom call as if it's a conference call, and then they can just hear everything. So that's also an option for the public. Because I hear your reservation, and I'm 100% with you. I want to make sure the public has access all the time, but that is available.
Right. I thought we've had a complaint where Zoom was set up for board members, the public could call in and participate, but it didn't work, and people were frozen out inadvertently.
That was user error.
Yeah, that was a technological error, and yes, anything we do, we're going to have technology to address. But as we've encouraged government bodies, let's think through, pre-plan, what those technological issues might be, so that we can come up with contingencies.
And what was the recent complaint? You could only come into the room when it was your turn to speak or your chance to speak, and people then couldn't hear the rest of it. There are a plethora of issues.
Yes.
And there's a Luddite streak that runs in me, that's for sure. But I just don't want a format that everybody can't use or can't participate in or gets cut off. But send me emails. I never thought conference calls would extend this far, but there's still the end is not still in sight for this COVID-19 to go away. So if people want to try to have a format where we can see each other, there's some advantages to that. That's for sure. Then we can work on it, but I want to make sure that's something the board members think should be a priority, where we abandon the conference call idea. And yet, this is an ugly admission, but I've never used FaceTime on my phone or my iPad. And I have a friend who's very ill staying with me, and I needed to change an appointment in Iowa City with the doctor, and he was persistently persuasive. He wasn't going to take no for an answer, and insisted on calling me back on my iPhone using FaceTime, because he wanted to show us a little drawing of the innards of the person and where the tumor is and what he had done. And it was actually quite helpful, so I'm making progress and using other technology.
When our agenda says that the next board meeting will be held in the Wallace Building, 3rd floor, I know technically that's true because that's where it originates, but maybe the agenda should also say if it's going to be electronic.
Well, Rick, we list it that way on the agenda because aspirationally the next meeting is going to be in person in the Wallace Building. And we don't make the determination to go electronic until approximately 2 weeks out, when we start having to put things together for the meeting with you all. So we could, if you don't mind, we could put in parentheses that possible electronic meeting, so I can make note to make that change next month.
I think that'd be good, Brett.
Okay.
Anything further, or are we ready to adjourn? We have a motion to adjourn?
Keith, I move we adjourn. This is EJ, I second we adjourn.
Was that moved by Keith?
Yes.
Yeah, moved by Keith, seconded by EJ. Voice vote. All in favor? Aye.
Aye.
Bye, everyone.
Bye-bye.
It's 3:50 p.m.